everyone, welcome back to This Week in Immigration. I'm Jordan LaPier. This week, the latest on the DACA court battles, an update on family reunifications, and our latest study on deterring unauthorized immigration. All that just ahead. But first, remember, you can subscribe to this podcast on Apple Podcasts, Google Play, Stitcher, or wherever you get your podcasts. And while you're doing that, leave a review to help more people find this program. You can also stream This Week in Immigration on our website at bipartisanpolicy.org. And as always, check out bipartisanpolicy.org/immigration for more information on the stories we discuss here on the show. All right, let's get into it. Here today with me are Teresa Cardinal-Brown, Director of Immigration and Cross-Border Policy. Hi, Teresa.
Hi, Jordan.
Chris Ramon, Policy Analyst. Hi, Chris.
Hey, Jordan. How's it going?
And Tim O'Shea, Immigration Policy Intern, here for the last time on the program. Hi, Tim.
Yep. Hi, Jordan.
All right, let's start with DACA, Teresa. Last Friday, a U.S. District Court judge in Washington, D.C. ordered the Trump administration to restart the DACA program. And that came after he gave the administration an opportunity to justify ending that program after he gave an earlier ruling that called for it to be restarted. So why did the judge restart the program or reaffirm his decision to restart the program after taking a look at the administration's justification?
What basically happened is that the Department of Homeland Security issued a memo, the Secretary of Homeland Security, Kirstjen Nielsen, issued a memo in June that declined to basically overturn the prior memo that ended the program that Elaine Duke, the acting secretary, had issued, and essentially reiterated all the same rationales or most of the same rationales in that original memo. So the judge looked at this and said, you didn't really tell me anything new. You didn't substantially expound on your reasons for why you decided to end the program in the first place. So you didn't give me any more reason to say that this is better rationalized before. His original decision said that the government had not properly evaluated the legality of the program, and therefore its decision was arbitrary and capricious. Under the Administrative Procedures Act, government cannot take actions that are deemed arbitrary or capricious where there are people that are relying on those government decisions. In this case, all of the DACA recipients. So he did order the program to be fully restarted. So up until now, previous injunctions in California and Maryland had required the government to take reapplications for people who are already in the program. This would allow the program to be fully restarted for allowing for new applications, right? But he again delayed that in part because I think he knows that there are these other cases that are pending up through the appeals process in California and Maryland. We have this other case in Texas, which I know we're going to talk about, and he knows the government's going to appeal this case anyway. So I think he gave it another week and a half, basically, to August 23rd before his ordering the program reinstated kicks in part because to allow for those appeals to take place, and possibly the appeals court may stay his order pending the appeal. So in essence, though, it may be a little bit of a disappointment that the program's not restarted. It would probably be worse off if it was restarted and then stopped again a few weeks later.
Sure, we've talked a lot about the uncertainty and all that.
The uncertainty and confusion for people who are kind of in the limbo. So that may be another reason why he's saying, look, I know this is all going to be appealed. Rather than try to start a program and then stop it again, let's just
give some time to let everything play out and see where we stand.
Yeah.
So the judge also threatened to vacate the memo that the administration issued to end the DACA program. Can you explain what that means and what would happen if he took that step?
Sure. And actually, the order did sort of vacate the memo. But basically, it said that memo is null and void, that it wasn't, again, properly explained the legal rationale for doing it or the rational policy decisions that are defensible legally by the administration. Therefore, it was deemed arbitrary, capricious, and as if it never happened. So again, by basically revoking that memo or rendering that memo null and void, they would have to restart the program under the same rules and conditions as it existed prior to the issuance of that memo.
So we're also waiting for a U.S. District Court judge in Texas, which you mentioned, to do a review of the program's constitutionality. And there's a hearing. As we're taping this program right now, that case is being heard down in Texas.
Yeah.
Can you explain what would happen if he decides that the program isn't constitutional, and then we've got other district courts that have ruled that it is, and we've kind of got a standoff?
Yeah. So just to be clear, the other courts so far haven't ruled on the constitutionality of the program itself. Judge in district court in D.C. said that they didn't terminate the program under the Administrative Procedures Act. He specifically did not address the constitutional questions that arose in the thing. So we need to sort of separate that a little bit. The constitutionality program has not been ruled on yet. The judge in Texas, this is the case that was filed by the state of Texas and other attorneys general, the same group of people that filed under the Obama administration to end his expansion of the DACA program and the DAPA program, which would have been for parents of DACA recipients and other U.S. citizens. That judge is widely, because of his conservative bent, expected to rule in favor of the states. We don't know for sure, but that's a large expectation a lot of people have. Mm-hmm. If he were to rule in favor of the states and issue a nationwide injunction against the program, that would be directly contradictory both to the existing cases in California and Maryland and the new ruling by this judge in D.C. Normally, when you have conflicts like that, that would go to the Supreme Court, and almost immediately the case would be appealed. In fact, the judge in Texas, actually DOJ, when they filed their response in Texas, asked the judge if he's going to rule in their favor to actually stay his ruling so that they can appeal it, because if he were to issue that ruling, they would be stuck. They could not do anything without violating some judge's order. If they continued to accept cases, they would violate the Texas judge's order. If they didn't accept cases, they would violate 3 other judges' orders. Yeah. So they basically said, don't put us in that position. If you're going to rule in our favor, stay it so we can appeal up to Supreme Court.
So that would be the next step, is an appeal to the Supreme Court.
That would most likely be the next step. Normally it would go through the district courts. Those other cases in Maryland and California are going through the district courts. But in this case, there's such, I think, an obvious conflict among the courts that waiting for that process would be detrimental to the government. And so there's a good chance the Supreme Court would say, okay, we'll look at it in this case. You know, the other thing to bear in mind, though, is right now we have an 8-judge court.
Yeah.
And although President Trump has nominated Judge Kavanaugh to that position, it's unclear when he's going to be confirmed. So it may be a while even before we have a Supreme Court ruling. If the case is accepted by the 8-judge court and ruled on by the 8-judge court and they deadlock, that would leave the state of uncertainty in place. That's what happened with the DACA and DAPA program. At the time that went to the Supreme Court under the Obama administration, there were only 8 judges. They deadlocked, and that left Judge Hannon's order in place. So something else to think about is that we're not done litigating this out.
So a lot more yet to come.
Yeah.
Thanks, Teresa. Now let's turn to the ongoing government effort to reunite families separated at the border earlier this year. Teresa, I'll start with you again. How's the process going? Has the administration met the court requirements ordering those reunifications?
Well, if you ask the government, they say they did. They reunified everybody they deemed eligible to reunify. The plaintiffs in the case, the ACLU and the other advocate groups who filed against the government, said not so fast. Of the number of children who were separated from parents, about half of them were reunited, either inside the United States or in detention. Another half have not necessarily. About 700 cases remain outstanding. The government says that probably about 400 of them are parents who were deported already without their children. So they are back in their own countries, and the government says we don't know where they are. Another substantial number are people that, for one reason or the other, the government is deeming ineligible to reunite with the child. Either they can't prove a relationship or they're concerned that they may be a harm to the child's safety. And there's some portion of them that the government believes are present in the United States and they can't locate them. That's a smaller number, maybe about 70. So that's the group that they're saying are ineligible. Now, the government told the court that for the folks who have already been deported, that it is no longer their responsibility to try to find them and try to reunite them with the children. They said it should be on the ACLU with their considerable resources to do that. The judge disagreed very clearly with that argument and said, nope, you're the responsible party here. It's your actions that rendered these children essentially without their parents. And if you fail to reunite them, you will have created orphans. So that is a very strong ruling from this judge, but that still doesn't say what process is going to be used to try to reunite them. The judge ordered the government to come up with a plan and name a point person to work with these NGOs to try to find these parents and reunite them. That's still pending.
Chris, you wanted to jump in here?
Oh, yeah. I mean, the thing is that, the overall process is it isn't playing out as largely as the government expected it to. And I think that if you're looking at the various reasons as to why they haven't, obviously the administration has been trying to claim that some of these parents have been ineligible, trying to sort of say this is one of the reasons why we have to be able to delay the whole process. But at the same time, I think as the congressional testimony showed, there may have not been a plan in place
to do this until the judge ruled. Yeah. So that brings us to the congressional hearing. There was a Senate Judiciary hearing last week.
So just a little bit of background. Representatives from the Border Patrol, ICE, Citizenship and Immigration Services, and DOJ testified last week before that Senate Judiciary Committee. It got pretty testy.
It did.
Walk me through what they said, and what do we think Congress is going to do anything legislatively about this issue?
So there, as you mentioned, there were representatives. They were not the heads of those agencies. They were sort of operational leaders. So the head of the Border Patrol, the person in charge of enforcement and removal at ICE, the person in charge of refugee and asylum applications at USCIS, and the head of the immigration court system at DOJ were the bureaucratic members who were testifying. They were questioned very harshly, especially by the Democratic members of the committee, about the process, the plan. At one point, they were asked if any of them thought that this program of zero tolerance and family separations was a success, and none of them raised their hands. They all indicated there were difficulties and problems. They supported the policy in one form or another, but said it hadn't been carried out properly. Another important thing that came out of the testimony was they were all asked when they found out about the zero tolerance policy, and almost all of them found out about it either the day of the Attorney General announcement in April, or maybe shortly before or shortly thereafter. So again, they weren't given a lot of time to plan for implementation. There was conversations about how this reunification process was to happen. And again, it was very clear from the testimony that there wasn't necessarily, at the time this policy was put in place, any plan to try to reunite parents and kids. At one point, the ICE agent was asked whether all of the parents who had been deported, whether they had proof that they all agreed to be deported without their children, and he didn't really answer that question clearly. So we don't know. There's allegations that those parents may have not understood that they would be deported without their children. They have incorrectly assumed that they would be reunited with their children, or just believe that the only way they could get their children safe was to sign a paper. So this is going to be ongoing again, and all of this is fodder for the litigation that's going on as well.
So, Chris, let's take a step back. Customs and Border Protection released its latest apprehension numbers that track apprehensions along the U.S.-Mexico border since the implementation and suspension of family separations. So what does the data show?
So if you're looking specifically at the number of apprehensions of family units from the time the zero tolerance was implemented in April to now, those numbers have remained flat. And I think that has some pretty serious implications for how the program's been effective in actually deterring these individuals from coming into the U.S. illegally. So if you're looking at the numbers, basically the numbers have been around, give or take, up or below 9,500 from April to June.
9,500 apprehensions per month.
For family units, which means are individuals. Family units means like individuals that are traveling as part of a family.
Got it.
And so if you're looking, doing this period is about, like I said, 9,500 family unit apprehensions from April to now. If you're looking at the overall apprehensions along the U.S.-Mexico border, it saw a decrease by 7% compared to June of last year, but that's because there were fewer unaccompanied children who were being apprehended at the border. But once again, the key thing is the numbers of family unit apprehensions has remained flat. And that's been reported on quite a bit, today and yesterday, that these numbers have been reported, because obviously a lot of people have been waiting to hear and see what the apprehension numbers were going to be for family units since the implementation of this program. I think we mentioned this a few weeks ago in one of our podcasts, that it remains to be seen whether or not the policy was going to have any type of deterrent effect, or whether it could be detected. And at least from these numbers, at least this reading, it might be the case that that's not, that the policy may have not had the effect that the administration.
So you're saying it might be the case. So are we ready to make any sort of definitive conclusions about whether this policy has been effective in deterring?
There are a lot of things that we have to take into account to make that conclusion. I don't think we're there yet in making that definitively. I think a couple things to consider. The administration has been saying, when these numbers were released and trying to defend themselves, they were saying, well, it takes about 2.5 months for information about this policy and how it's affecting people who are coming to the U.S. to travel down by word of mouth or through news media down to the sending countries, so that way people know and hear about that, and then they subsequently adjust their plans for coming up to the U.S. That's what they're saying, is that it's like, we haven't there hasn't been enough time for this information to pass along, so we can't really know what the long-term effects are. And that's the argument that they're saying. But I think if you're looking at it more holistically and just looking at what could have happened, to be honest, I think that the thing is, it's just too short of a period of time for us to really know whether or not this would have had a long-term effect. There was, I believe the Center for American Progress did put out a study that was saying that used statistical analyses to show that that this policy did not deter these family units or these family members from trying to come into the U.S. But once again, the issue there is that it's just such a short period of time that we'll really never know, because the policy that was then suspended, that we'll never know what the long-term impacts would have been for this policy. We only have this data point. We have Center for American Progress with their study, or the administration with their claims, kind of trying to explain why the policy didn't work. But at the end of the day, with 3 months of data points and a policy that's now left in shambles, we won't really know what would have happened. And I'm sure what will happen as results, you'll probably see the administration, I think I said this on Twitter, if the apprehension numbers click up a little bit later on this fall, and if they click up because they're kind of adjusting for seasonal alignment with what you normally see around this time of year, the administration will start saying, well, that's because you got rid of zero tolerance policy. If we had it for a longer period of time, it would have been deterrent. So I think that you may be seeing that may be something you might be seeing down the line.
Thanks, Chris. All right, and finally today, sticking with this topic of deterrence, Tim, you just authored a piece on our blog that examined the limitations of rhetoric when it comes to deterring undocumented immigrants. Tell us a little bit about your study and what you found.
Absolutely. We essentially devised a way to predict apprehensions over the typical fiscal year and then compared those projections with apprehension numbers in 2017. So it was well documented in 2017 that there were really abnormally low apprehension numbers at the border, and our research mainly confirmed that. At the peak of the effect in April 2017, a typical year would have experienced 50,000 more apprehensions than actually took place. But there were two major takeaways from that data and those models. The first is that the drop started before President Trump actually even took office, and long before he instituted his major border security actions, such as deploying the National Guard to the border. This is why we believe that it was primarily the effect of the president's rhetoric and threats that drove the drop in apprehensions. However, the second major takeaway was that the effect of the rhetoric was very short-lived. By November of 2017, apprehension numbers had returned to typical levels, and there was even a short above-average increase in apprehensions for about 3 months after that. This is where we derived the main lesson of the research, which was that rhetoric and tough talk aren't sufficient to maintain deterrence at the border. You need actual substantive policy change.
So in other words, rhetoric facilitated a short-term drop in the number of border crossings, but it wasn't durable over the long term.
Yeah, and it really comes back to what Chris was just talking about, which was even though the news was full of clips of President Trump saying he was going to secure the border, once migrants through word of mouth figured out that nothing had really changed, then the effect subsided because they essentially figured out that they could go back to business as usual.
So you also looked, though, at apprehension numbers along the U.S.-Mexico border after U.S. Customs and Border Protection came online in 2003. So do those figures point to similar findings as your review of the recent times?
So we found a similarly shaped effect when we examined that period when we used the same method as we did for 2017. So the Homeland Security Act was signed in November 2002, and by January 2003, apprehension numbers were lower than what we would have otherwise expected using the model. By the time that CBP officially began operations in March 2003, apprehensions were about 31% lower than the model would have predicted otherwise. However, as with the effect in 2017, that too faded pretty quickly. By June, just 3 months after CBP began operations, apprehension numbers were back to a normal level that the model would have predicted. So we once again found a pattern consistent with the idea that perception didn't create sustainable deterrence and similarly subsided.
So I've sort of got a sense of your perspective, but Chris, I want to get yours as well. What can we conclude about whether rhetoric can actually make a long-term shift on undocumented immigration? Does it require more than tough talk, or is tough talk enough?
It's not enough. I think one of the things that separated these two periods that we looked at is probably the largest drop in apprehensions, basically 2001, 2002, 2011, just a precipitous drop, to historic levels and historic lows. And the reason that happened was for several reasons that had nothing to do with perception. It had to do with three core things. One, there was effective enforcement at the border, both under the Bush and Obama administrations, that did deter undocumented immigrants from coming to the United States. But two, you also had changes in demographics of individuals who were coming and not coming to the United States. You had more individuals coming from the Northern Triangle countries in Central America coming, but immigration from Mexico just dropped off. There was a demographic shift in terms of the number of individuals who are aged to migrate who tend to migrate to the United States. I think ages of 19 to 34, give or take, Mexican men. That population actually shrunk during this period. And you also had the Mexican economy doing a lot better. So the idea that more individuals from Mexico were going to move to the United States or try to move there illegally just didn't happen. Just fewer people were coming from Mexico, more people were coming from Central America, but the people coming from Central America didn't offset the drop in number of individuals coming from Mexico. And then, of course, there's economics. The Mexican economy was doing really well. We had our Great Recession, and that obviously impacted the number of people who wanted to come to the United States. So you have enforcement, you have demographics, you have economics. Take all those things together, and you will see sizable shifts in apprehensions like you did between 2001 and 2011. But if you have just rhetoric, if you have perceptions from 2003, you're not going to see real long-term changes because you don't have policies that you have in place to deter illegal immigration. But you don't have also some of the other shifts of demographics and economics that impacts why people would want to come here in the first place. So if we look at the current situation right now, obviously the big thing that we would need to address is the violence in the Northern Triangle countries. I mean, that is one of the definitive factors of pushing people to come here in the first place. And so you can have all the tough talk in the world, but tough talk that doesn't address also the real tough realities that people have in these countries and the levels of violence that are in there. El Salvador has the highest homicide rate on earth. I mean, that kind of fact and those realities, I think if you can deal with that, then you can deal with addressing illegal immigration coming to the United States. But as long as it's just tough talk and you don't have any changes in economics, demographics, or any of the conditions in the sending countries, you're just going to keep saying tough talk, do very little.
I think that's an important point. Thanks, Chris. And thanks, Teresa. And thanks, Tim. And a special farewell to you on your last episode. Wishing you well in the fall semester.
Thank you, Tim, for all your work.
Thank you.
Thank you for having me.
And thanks to you all for listening, and a special thanks, as always, to our producer, Emily Schrader. Please take a second to find us on Facebook by searching Bipartisan Policy Center, or on Twitter at BPC_bipartisan. And don't forget to subscribe and leave your feedback on this podcast on Apple Podcasts, Google Play, Stitcher, or wherever you get your podcasts. Just search Bipartisan Policy Center. Join us again next time on This Week in Immigration.